Welcome to This Week in Education Law, School Administrator's Guide, episode number 4. Each week, I share up-to-date court decisions on education law. I pay special attention to the court decisions and arguments related to school administrators' daily work. Today, I focus on a case about discrimination in hiring. Here is a question. Is it adverse employment action if you cancel the job posting to avoid hiring an applicant of your disfavored class, such as gender, race, and age? Adverse employment action means a significant change that negatively affects the employee's employment status, such as hiring, firing, or failing to promote. An adverse employment action is a prerequisite for a Title VII claim of the Civil Rights Act of 1964. Title VII is the main federal law that prohibits employment discrimination based on race, religion, national origin, color, and sex. This means that an employer cannot take an adverse employment action such as refusing to hire, demoting, refusing to promote, and firing against an employee or potential employee based on any of those protected characteristics. So an adverse employment action is a prerequisite for Title VII claim. This case is about a university department canceled a faculty search because the dean wanted to hire female candidates, but the search committee recommended a male candidate to be hired. Even though the setting of this case is in higher education and the hiring process can be different, the rationale behind the court decision applies to K-12 settings as well. In 2017, Department of Biological Sciences at the University of Cincinnati decided to hire an assistant professor. A total of 62 candidates applied. The search committee, which included 4 faculty members and 1 non-voting graduate student, selected 9 top candidates for interviews via Skype. One of them was candidate Dr. Mark Charlton-Perkins. He was a male and U.S. citizen working as a research scientist at the University of Cambridge in the United Kingdom. After the search committee assembled its list of top candidates, the committee chair, who was a faculty member in the Department of Biological Sciences, realized that she had collaborated with Charlton-Perkins on various projects in the past. She alerted other committee members about the previous collaboration. The committee chair also consulted with the director of the Office of Diversity and Access and the superintendent of graduate student recruitment, who assured the committee chair that there was no conflict of interest. After the online interviews, 5 finalists were invited for on-campus interviews. 1 female candidate declined. After the on-campus interviews of the 4 finalists, 1 male candidate was eliminated. The search committee took its final vote on the 3 finalists, and Charlton-Perkins was rated the favorite by a vote of 3-1. 3 days after the search committee's vote, the committee chair met with the department chair to inform him of the committee decision that Charlton-Perkins was recommended by the committee to be hired, and the 2 female candidates in the committee rankings. The department chair, for the first time, told the search committee chair that the dean of the college had decided to hire 2 candidates for the position instead of 1. About a week later, the department chair told the search committee that the dean believed the most appropriate course of action was to focus on the women candidate first, and the dean felt that he might make a case to hire 2 strong women candidates. The search committee chair responded on the following day, saying, putting 2 lower-ranked candidates up first It's not only against the recommendation of the committee, but also plain discrimination. On the same day, the department chair emailed the search committee chair explaining that your advice and discussion of the candidate's strengths and weaknesses, along with my own judgment and extensive discussions with the dean, has guided the choice of actions. In the email, the department chair also asked the search committee chair to understand how difficult this decision has been for me, but that the dean and I had agreed with the ultimate hiring choices we have made. 3 days later, the dean met with the search committee chair and announced that the search had been tainted by the committee chair's past collaboration with Charlton-Perkins, who was recommended to be hired by the committee. The committee chair reminded the dean that her past collaboration had been disclosed before the interviews, and the director of the Office of Diversity and Access and the superintendent of graduate student recruitment of the college assured her that there was no conflict of interest. In less than a week, the dean informed the faculty that he believed an equitable search was impossible under the circumstances, and thus he was canceling the search in its entirety. Charlton-Perkins filed a lawsuit alleging that the university failed to hire him solely on account of his gender, and the department chair and the dean violated his equal protection rights against gender discrimination. The district court dismissed Charlton-Perkins' complaint because the job search was canceled and nobody ever filled the canceled position. Charlton-Perkins' claim never ripened into an adverse employment action. Charlton-Perkins appealed. The Sixth Circuit reversed, holding that Charlton-Perkins plausibly alleged both a de facto injury and a ripened employment discrimination claim. The court reasoned that no matter whether somebody else ever got the spot, it has always been the case that Charlton-Perkins was denied the spot. So the Charlton-Perkins has always had the de facto injury. He has always been stuck with the denial, no matter whether someone else got the position instead. When an employer discriminatorily cancels a position to avoid hiring an applicant of a disfavored class, a job applicant needs not establish that somebody else filled the position. If the applicant can establish that the employer canceled the position specifically to unlawfully discriminate against the job candidate. In this case, the university not only failed to hire Charlton-Perkins because of his gender, but they then added the insult by canceling the position as a pretext to conceal the discriminatory reason for the failure to hire. The court agreed with Charlton-Perkins' argument that a discriminatory failure to hire plus a discriminatory cancellation of a job opening still constitutes a cognizable adverse employment action, even though nobody was ever hired for the job. The case I just introduced was about a discriminatory job cancellation based on gender. Here, I'll introduce a similar case, but the job cancellation was based on race. In Evans' case, Evans was a 54-year-old African American working as a GS-13 in the Department of Health and Human Services. GS-13 is the highest grade in the general schedule pay system in the federal government. This means that once an employee reaches GS-13, the only way to continue increasing their pay is to change career tracks to supervisor or another career path that includes higher grades. Immediately upon entering the White House in 2001, the Bush administration imposed a hiring freeze. Still, in March 2001, the outgoing commissioner, who was a holdover from the Clinton administration, recommended the creation of a GS-14 position. Evans applied for and was interviewed for that position. On July 17th, Evans and another African American were selected by their direct supervisor for the two positions. But because of the hiring freeze, neither of them was promoted. Over the next few months, the new administration replaced the hiring freeze with a series of hiring controls. And in March 2002, Assistant Secretary for Children and Families announced in a meeting that the hiring freeze was no longer in effect. Despite the relaxation of the hiring controls, Evans was never promoted to the position, and she retired in April 2002. Both before and after her retirement, Evans attempted to find out why she had not been promoted. After exhausting her administrative remedies, Evans filed a lawsuit in the United States District Court for the District of Columbia. Evans alleged that the department's failure to promote her to the newly created position was due to race discrimination. The district court held that Evans failed to rebut the government's legitimate non-discriminatory reason for not promoting her, that the position was canceled administratively. Evans appealed. The United States Court of Appeals, the District of Columbia Circuit, held that the Department of Health and Human Services may engage in pretextual cancellation of a position to avoid hiring African Americans. There was sufficient evidence supporting that the department, first, offered inconsistent and inaccurate explanations, second, promoted whites but not African Americans during the hiring controls, and third, is unable to identify who canceled the position. With the evidence, a reasonable jury could find the department's proffered explanation to be nothing more than a veil for racial discrimination. Since the department put forward a legitimate, non-discriminatory explanation for its decision, Evans needed to provide evidence that casts doubt on, first, the employer's proffered reason by, among other things, pointing to changes and inconsistencies in the stated reasons for the adverse action. Second, the employer's failure to follow established procedures or criteria. And third, the employer's general treatment of minority employees or discriminatory statements by the decision maker. In this case, the department gave shifting reasons for the non-promotion. Evans was told she would be promoted once the hiring freezes was lifted, only to learn later that the position had been administratively canceled after the hiring freeze ended. Those shifting and inconsistent justifications are probative of pretext for racial discrimination. Second, the Assistant Secretary for Children and Families had the authority to approve Evans' promotion during the hiring controls, but he did not. Instead, the department promoted white employees but not black employees. However, in a letter to a senator, the Assistant Secretary explained that Evans could not be promoted because of the hiring controls. A jury can reasonably infer from the falsity of the explanation that the employer is dissembling to cover up a discriminatory purpose. Moreover, it was unclear who canceled the position. The acting commissioner testified that he discussed the position with the commissioner who expressed no interest in creating the position. But the commissioner testified that she had no role in the final cancellation of the position because all GS-14 positions were removed from her consideration and no longer existed. Also, the documents released in response to Evans' Freedom of Information Act request revealed that the hiring controls posed no barrier to the promotion of at least 3 white employees. So the hiring controls were not an impermeable barrier. A reasonable jury could infer that the promotion of white employees but not black employees during the hiring controls is evidence of pretext. Third, a reasonable jury could interpret the behavior by the commissioner and her executive assistant as racially insensitive. The commissioner's highest-ranking black subordinate testified that the commissioner frequently referred to African American women on staff as those sisters. In a different case, the use of the term boy to refer to African Americans can be evidence of racial animus under certain circumstances. The commissioner's subordinate also recounted an incident in which the executive assistant implied that people from the hood were liars and cheaters. The commissioner failed to respond immediately to those remarks, although she eventually reprimanded her executive assistant. Given this evidence, the District of Columbia Circuit held that the Department of Health and Human Services may engage in pretextual cancellation of a position to avoid hiring African Americans. With the introduction of the two cases, you should have the answer to the question I posed at the beginning of the video. Is it an adverse employment action if you cancel the job posting to avoid hiring an applicant of your disfavored class, such as gender, race, and age? Cancellation does not prevent a job applicant from filing a discrimination claim as long as the applicant can establish that you, as an employer, canceled the position specifically to unlawfully discriminate against them. When you discriminatorily cancel a position to avoid hiring the applicant of a disfavored class, the applicant need not establish that somebody else filled the position. Your argument may not stand in court if you say, because nobody get hired for that position, the applicant suffers no harm. The court would reason that the applicant is denied the position no matter whether someone else is hired for the position. I hope the two cases I introduced today is helpful for your hiring practices. I'll see you next week in This Week in Education Law, School Administrator's Guide.